Cool. All right. Who else did not know you could get upstairs this way? I had no clue this was a thing, so I'm glad I'm not the only one. I appreciate you guys coming tonight. I'm super excited. I've been looking forward to this night, really ever since Pastor Sampson and I started talking about the class. I think estate planning is one of those things that confuses a lot of people, worries a lot of people. Sometimes you're worried and you don't know why you're worried when you feel like you're supposed to be doing something and you're not doing it. I feel like estate planning can kind of be one of those things. So hopefully tonight we'll shed some light on what it means to have an estate plan, why it's important, and just some of those moving pieces there. So I'm going to keep things moving along. I want it to be a dialogue, so if you have questions, just shout them out. There's not a stupid question tonight or any other night. There's never a question that you shouldn't ask. Just like last time when we got together, if there's something you want to ask and you don't want to do that in front of all your friends here, I'll stick around afterwards, and I'm happy to answer questions one-on-one with you guys afterwards. So I just thought it'd be good to kind of highlight some reasons people don't create an estate plan or haven't done that yet. And so these are some reasons that I've heard in my practice throughout the years. First off, I don't know what I don't know, right? And I think that kind of sums up where most people start on estate planning. It's something they just don't know a lot about. And so where do I even get started? What do I even do to get going? They're afraid of the costs, right? People know if you're hiring an attorney or you're hiring a professional to do something, probably means you're going to have to pay for it. And nobody really wants to get overcharged, or they just don't know how much the bill is going to be. And so money can certainly be a question there. Faced with mortality, I don't want to think about it, right? When we're doing an estate plan, we're kind of contemplating our own demise, right? Well, I have news for everybody. Everybody in this room is going to die one day, right? Like, we know that. That's just kind of the reality. So, but that's certainly a reason people put it off. A couple other things people say: I don't think I have enough money. I don't have enough assets for it to matter. It's not I don't own enough stuff. It's really not important. Or, hey, my family, we just get along. Everything is coming up roses. We never fight. Our kids are never going to argue. I have seen people fight over the most inane, frankly, like worthless, stupid, silly things whenever they experience the loss of family, if there's not a plan written out. So I'm confident everybody in here has awesome family. Just keep in mind we're all human, right? So just a little bit of estate planning fun. I couldn't help myself. True or false? Every person in this room already has an estate plan. Is that true or false? It's actually true, guys. It's true. Everybody has an estate plan already, whether you do anything or not. Your estate plan has been created for you by the state of Oklahoma or by your state of residency. And so if you don't do anything, guess who makes the decisions for you? The government. So you have to decide, do I want to be the one to choose what the rules of the road look like for my plan, or am I going to kind of cede that to the government? True or false, creating an estate plan must be complicated. That speaks for itself. It's false. I hope it speaks for itself. It doesn't have to be complicated. It can feel that way. I'm a baseball guy, so I had to work in a little baseball trivia. So true or false, the estate of George Steinbrenner, he was the owner of the New York Yankees. He owed the most estate taxes, or his estate owed the most estate taxes ever paid by a major sports team owner's estate when he died in 2010. You think that's true or false?
True, just because it's unique.
Okay, let's show of hands. True, who thinks it's true? Okay, who thinks it's false? Okay, it is actually false. George Steinbrenner was such a good money guy, he timed his own death to die in the 1 year over the last 50 years where we have not had an estate tax at all. We had an unlimited amount of assets you could die with in 2010 and not owe any estate tax. So $1.1 billion, that's the value of his estate when he died. $1.1 billion went to his heirs. No estate tax owed. And then lastly, so the number one reason to create an estate plan is A, reducing federal estate taxes. Maybe that's important, maybe not. B, getting to work with a lawyer, because everybody loves doing that. C, sticking it to the man. Everybody likes sticking it to the man. Or D, making sure your wishes are followed. D is hopefully everybody is saying I want to have a good rules of the road for what I want to have happen with my stuff. So let's talk through what an estate plan is made up of. An estate plan is made up of several different documents. So these are legal documents that ultimately are giving effect to what you want to have happen with yourself, with your own person, with your stuff, with your income, with all of your assets while you're living, and in the event that you become incapacitated, in the event that you die, in the event, if you're married, in the event that your spouse dies. That's really what an estate plan is doing. It's just kind of laying out your wishes for what you want to have happen. And it's not all about death. There are a number of these documents that actually speak to what happens while you're still here, which I think for most people is as important, maybe more important than what happens when you're gone, because when you're gone, you're gone. But these are a handful of important documents. So a durable financial power of attorney, a healthcare or medical power of attorney, a living will, healthcare directive, a last will and testament, revocable living trusts, and irrevocable trusts. And we're going to spend the majority of our time talking about the first 5 documents. If we get time, we might touch on irrevocable trusts at the end. We'll see. Let's talk about what a durable power of attorney is. So a durable power of attorney is kind of it's a document that most people don't think of when you think of an estate plan. The first document people think of is typically a will, right? Because we've all heard of a will. We all wondered, am I in my grandma's will or my rich aunt's will or whatever? But some of these documents are really important. I want to make sure you know what they are. So a durable power of attorney is a document that basically lays out who gets to make decisions for you in the event that you can't make financial decisions for yourself. And so it's a document that can be revocable, meaning you can create it and then 2 days later you can say, forget that. I'm going to take that back and nullify it. You can amend it. You can go in and make changes to that document. Virtually everything that we'll talk about tonight in terms of what we put in place from legal documents, virtually all of the documents that you create as part of a basic estate plan can be changed. So something that I think is a stumbling block for a lot of people around estates is they think, oh, I don't know what decisions to make. I don't want to make the wrong decision, right? I don't want to do the wrong thing. And sometimes that analysis paralysis can keep us from actually taking the steps that we need to take. The cool thing about an estate plan is you can change it. If you make one provision and it works for right now and 2 years later something changes, you can go in and change it. That's the benefit. And so a lot you'll see on most of these documents, they're going to say revocable, amendable. So you can go in and change it. A durable power of attorney only affects events during your life. So the minute that you pass away, that durable power of attorney is basically extinguished at your death. And so it just appoints someone to take care of your financial affairs. Typically, you do that in the event you're incapacitated, in the event that you're unable to take care of things for yourself. However, there are times where it can make sense to have a durable power of attorney effective immediately. So let's say husband and wife want to be able to make decisions for each other. They don't want to have to worry about is the other incapacitated or not. They always want to be able to just step into their spouse's shoes. They're both really comfortable with that. You'd have to be really comfortable with that to agree to that, but sometimes people will make that choice. So you can have it made effective upon execution right away when you sign it, or you can have it effective at incapacity, which is what I would say the overwhelming majority of people want to do, because we all like control, right? Even if it's our spouse. Maybe especially if it's our spouse. And then what is an agent? So an agent is just the person who has the power of attorney. So a lot of times you'll hear people say, oh, I'm my spouse's power of attorney. The technical phrase is I'm my spouse's agent. The power of attorney is the document. The person is acting as an agent. And so usually if you have a married couple, usually you have your spouse serve as the agent. And then, next in line, I think it's always good to have backups, and then to have backups to the backups in all of these documents. All these documents will have provisions, like what does the document do, and then they'll have people. The people are who are kind of stepping in to be involved in that process. And so, maybe if you're not married, it may be a parent, it may be a sibling, it may be a close friend, but someone to kind of step in line to do that for you. Any questions on durable power of attorney? Anything I covered there that doesn't make sense?
I would wonder, how challenging is it to make amendments?
It's not challenging at all.
Just contact the attorney and...
Yep. So let's say,
Cost additional money.
well, I think, when you're looking at costs, most estate planning attorneys will provide estate plans via a flat fee. So you would kind of know up front, here's what it's going to cost. It's not an open-ended, well, maybe I'll bill you 5 hours, maybe I'll bill you 20 hours, like what you would see maybe in litigation or family law, that type of thing. But in estate planning, it's usually up front, an estate planning attorney will tell you right up front, hey, it's X amount of dollars. And then if we make amendments, if there are minor amendments, we charge X for an amendment to to the durable power of attorney usually. And usually those amendments are going to be, if I say nominal, I don't mean to minimize the cost, but it's not going to break the bank. In terms of what we're doing here.
I had a question too.
Yeah.
When it comes to being or at incapacity,
Uh-huh.
how specific does that have to be, or would that on the document be very specific as how they define incapacity?
Yeah, so incapacity is typically defined, I say most commonly, as two doctors, stating that you're incapacitated, or maybe your primary care physician. If it's just one doctor, it'd be the doctor that knows your healthcare situation the best. So it's not just based on, well, so-and-so thinks I'm incapacitated, or I've been acting kind of crazy lately. It's based on a medical opinion. Any other questions on the durable power of attorney piece? In terms of just the powers, what does a durable power of attorney document give an agent the power to do? These types of things. So really anything you would do in your financial life. You can, buy, sell, transfer assets, receive income, manage financial accounts, execute certain legal documents, enter into a contract, borrow money, loan money, handle tax affairs, make gifts. So those are the types of things. That's not an exhaustive list, but yes, sir.
So are we allowed to ask, like, what's the price range for something like this? You said, like, nominal cost, I don't know, 1,000, 10,000, 200?
Yeah. Yeah, you bet. So for the folks watching by video, just the question was, in terms of cost, what are we looking at? How much is it going to cost? It's going to depend on the complexity of your circumstances. It's going to depend on the kind of the structure of the law firm and what all you're engaging them to handle. I would say the range, I've seen estate plans that don't have all of these documents, that maybe cherry pick one or two documents that would be $400 or $500. I've seen estate plans that, 5,000 or more. I would say most commonly, if you walk into most law firms in Oklahoma City and say, create a comprehensive estate plan, you're probably looking at $3,000 to $5,000. You can certainly pay more than that. And at times it's, I can certainly justify the need for those expenses. Marshall, to your point around, hey, we're going to have to pay for amendments or changes, usually an attorney will let you know up front a ballpark range of what an amendment would run you. If it's minor, let's say in your durable power of attorney, your second in line person passed away, and so there's just a logistical reason why we have to go back and add someone else. That's a relatively simple, relatively minor change. Probably $200 to $300 is what I would guess that type of change would cost. Yeah, you bet.
If someone becomes incapacitated,
Uh-huh.
and then let's say they come back to themselves, they have to go get it signed off by a doctor again?
That's a great question. It's going to depend on the circumstances. If they've, let's say they went through a surgery and we know they're going to be out of pocket for a bit, or something had happened and they feel like medically the determination that they didn't have capacity anymore wasn't valid, they could certainly go and either go back to those same two doctors or find new doctors, and then you can kind of turn into a battle of the medical opinions. So they are legal documents, and sometimes legal stuff can get a little fuzzy, but that's why you want to be as clear as you can on those terms. No, so the expiration date on a durable power of attorney is when you die. That's the expiration date. So it's your expiration date. Yep, exactly. You bet. Let us know when you're going to die, and I'll tell you when that expires too. So healthcare power of attorney. What is a healthcare power of attorney? It's very similar to the durable financial power of attorney, but it has to do with your healthcare. And so it's revocable, it's amendable, you can change it. It only affects events during your life. So whenever you pass away, the healthcare power of attorney doesn't have any effect. Sometimes I've had people ask, well, can my healthcare power of attorney make decisions about my funeral or what to do with my remains? No. When you're gone, this document is not effective anymore. But it appoints someone to tend to your health, to your medical affairs, in the event that you're incapacitated or unable to tend to them yourself. A really important point is that a healthcare power of attorney agent is not going to be able to override provisions of a living will. So we'll talk about a living will in just a moment. But a living will is another important document around what you want to have happen while you're alive, and then that document would take precedent over the decisions that your healthcare agent would make in a power of attorney. And so same deal with who the agent is. Usually it's a spouse first, and then a family member or friend, and I think it's good to have first in line, second in line, third in line. If you want to put fourth in line, you can. You know, it's never a bad idea to kind of over-prepare, so to speak. And then what can they do? Typically, you know, these four things are great examples. They can consent to your medical treatments on your behalf. They can, you know, hire and fire healthcare personnel. They can obtain your medical information and records, and then select care facilities. Maybe it's a long-term care facility, hospice care, or maintenance care in residence. So any questions on healthcare power of attorney for what that can do or what role that plays? Yes?
If you don't have one of these in place,
Mm-hmm.
I mean, is the spouse, I mean, and that person's incapacitated,
Mm-hmm.
or does it automatically go towards to the spouse for that decision?
Typically, medical professionals are going to look to a spouse to you know, for guidance. Then in that circumstance, they will also look to their own professional expertise. If it's, do we do surgery or do we not? Do we do X, Y, Z or not? They have their own standard of care as a physician that they're going to follow too. You can run into situations where, you know, let's say something happens to John Doe and he doesn't have a power of attorney, and family members have differing views on what healthcare outcome is most appropriate. In that instance, could you have a lawsuit, you know, filed, or could someone try to sue for guardianship of John Doe? Sure, absolutely, that definitely happens. And so if family members have conflicting views on what healthcare outcome is the right one for John Doe, then you can run into some of this in the absence of you making the choice ahead of time while you have all your abilities, who you want to be making those decisions for you.
So can one person do the durable POA along with the healthcare POA?
Uh-huh. Yep, let's say John Doe has two kids. Let's say he has, you know, James and Susan. And let's say, you know, James is the person to do both of those jobs. He has the financial expertise and he makes good healthcare decisions. And Susan doesn't want to be involved. Then James can do everything for his dad, John. If James is good at finance, but Susan is really compassionate and understands healthcare, you can split those roles and say, you know, my son's going to do the finance and my daughter's going to do healthcare. And you can always change that. Absolutely. Good question.
If someone is the first one, durable power of attorney, are they automatically also the healthcare? If like you didn't set up a separate one for healthcare? Or?
No, sir.
No.
Nope. Since they're completely distinct legal documents, you know, if you are let's say someone created a durable power of attorney but did not create a healthcare power of attorney, legal professionals, healthcare professionals are not going to assume that the financial power of attorney gets to be the healthcare power of attorney. I've had clients who've told me, hey, I want my daughter to be the financial power of attorney or financial agent. I would not trust her at all to make healthcare decisions for me because she wouldn't make good decisions because she would be freaked out, she would be emotional, and she wouldn't be able to make, you know, objectively good decisions. The doctors wouldn't be able to rely on her. And so, no, that's why they're distinct. That's one of the reasons why. Any other questions on the healthcare power of attorney piece? All right. So let's talk about a living will, healthcare directive. This is easily the funnest document that you'll ever get to do, because it has to do with the types of treatment that you want in really, circumstances that no one wants to really contemplate. And it's your end of life. So it's what kind of care do you want to receive if you have a terminal condition, you're expected to live less than 6 months. You're in a persistent vegetative state. In those types of circumstances, do you want nutrition and hydration? Do you want your life to be extended, if you were to code, so to speak? Do you want them to revive you and bring you back, or do you want to go on to your greater reward? Those types of decisions, again, they're hard to make. They're not fun to contemplate. I can promise you it's better for you to make those decisions ahead of time for your family than for your family to be stuck making those decisions whenever they're potentially grieving, they're emotional, there may be some level of financial stress at your loss. So don't put that on your family. Take ownership of it and do it yourself. You can always revoke and amend your living will, your healthcare directive. In Oklahoma, it's basically a statutory form. The state legislature created the healthcare directive, so any attorney that you go to is going to use that language that's right out of the state statutes. And so there are several questions that you answer, and then at the end of the document, there's an area for notes. If there are specific guidelines that you want to provide, you're able to do that. And I already noted this, but your healthcare agent can't override this. So if you said, hey, if I'm in a persistently vegetative state, I want to go home to Jesus as quickly as possible. Don't extend my existence here. Even if your child, who's a healthcare power of attorney, doesn't agree with that decision, and they say, no, I want mom or dad to stay as long as they can, the doctor is going to honor that living will. Any questions on that? I covered that kind of quickly, but there's a lot there to wrap our heads around. So a last will and testament. What's a last will, or what's the testament piece? So a will is the document that I think most people are most familiar with when it comes to their estate plan. We think through, do I have a will? Do my parents have a will? Does grandma have a will? And so a will is really the way I describe it as a Dear Judge letter. Because if you execute a will, what does a will do? It basically directs what happens to your assets, the assets of your estate, at your death. And so in practice, what happens, if I create a will, I don't create another document like a trust, but I create a will and I say, hey, I want everything to go to my wife, Lindsay, and then if she predeceases me, I want everything to go to our kids in equal shares. That won't happen automatically. It has to be activated. And it's activated through a legal process called probate. And so let's say 1,000,000 years from now that happens. I always kill off the guy first. So I die, everything goes to Lindsay. Lindsay dies, and then everything goes to Jack in Brooklyn. Jack and Brooklyn would have to hire an attorney to walk them through the probate process, which is a legal process. And so you go to court, and your attorney hands the judge the letter, or the will. And it's basically a Dear Judge letter. Dear Judge, here's what I want to have happen to all my stuff. Please follow my wishes. So that's what it looks like to pass on your assets via a will, if you're relying on the will. I will say, and I think a will is good, but we can improve on it. We can improve on only using a will for the outcome of your estate plan. I'll talk about that in a second. It is really critically important for families with minor children to have a will. Even if you're going to use other documents, you absolutely need to do a will in the state of Oklahoma, because a will is the document where you name who the guardians of your kids are going to be. And is that always a fun thing to think about? Absolutely not. It can be very difficult to decide sometimes, who do we want to take care of the kids? Who do we want raising our children in the event that both of us are no longer here? It's better for you to make that choice than for a judge to have my parents and my wife's parents in our absence fighting over who gets the kids, or to have your brother and your spouse's sister fighting over who gets the kids, or to be in a circumstance where nobody wants the kids And the judge is no one is stepping up to say we're willing to be the parent to these children, and a judge is having to look and say, there's not a great choice to be made here. So that's why you got to do it, and then it's important to loop that person into that decision too to make sure. Yeah, everybody's just going to name Pastor Sampson, right? And hope. Surprise! Yeah.
They have to be minors.
Right. So, yeah. So that's super important around minor kiddos. What are the roles called? An executor for a guy, or I didn't put the fancy name for female executors. It's executrix with an X on the end. Or a personal representative is kind of genderless. It's responsible for enforcing the provisions of the will. So the court would come in and say, you're the personal representative, and you're going to kind of run quarterback on this process. So if we transfer assets via a will, it does not avoid probate. We already kind of touched on that. But if we take a will and we couple it with another legal document called a revocable trust, then what role does the will play in that scenario? And I'll talk more about a revocable trust in a second. But then the will is just a safety net. It's to say, hey, if I didn't successfully transfer my assets or title my assets with a revocable trust, the will, it's still a Dear Judge letter, but it's just going to say, instead of Dear Judge, do XYZ with my assets, it's going to say, Dear Judge, pour over all my assets into this trust that I created. That was my intent. I just whiffed it and forgot to put this asset into the name of the trust.
Can I throw out a plug for that too?
Yeah.
So one of my coworkers, their parents, one parent was already deceased, but there's one parent left. They just had a will, and there's a real estate piece of property in that thing, but they didn't have a trust. And so, just like you said, it went to probate. And you were talking about the cost of it. Well, the probate on that house took 10 to 11 months to get it transferred. The cost by the end of probate was $4,000. They could have just had the trust and it would have immediately gone over, and it would have been the same cost. Not taken 10 to 11 months. So.
Yeah, exactly. Probate takes time. It costs something, right? A lot of times, to your point, it's going to be very similar in terms of cost for your estate to go do a probate compared to you ponying up the money now to go execute an estate plan. Perhaps, potentially more. You can actually spend a decent amount of money on probate, especially if there's conflict. If your kids or whoever would potentially inherit, if they're going to kind of fight over things or contest your will, then the sky's the limit on how much money we can spend in court. Lawyers, man. Lawyers. So here's what the probate process looks like. If you're wondering, is it the end of the world, by the way? No. I don't mean to make probate sound like it is the end of the universe. It's not. It's a fine way to transfer assets. It's okay. And if you ever run into a situation where a family member has passed and they don't have a trust, I don't want you to think, oh my goodness, we have a nightmare on our hands. No, it's to your point, it's just a little bit elongated. There's a cost to it. Here's what it looks like. So you file an application for probate with, we'd file it in county court, and then there's a waiting period where you have to serve notice to everyone that, hey, a probate case has been filed. The court will hold a hearing, which is just basically a meeting where they decide, hey, is this will valid or not? Did the person who passed away, did they actually create this will, or is this a false will? Did they have capacity when they created the will? And so all of those things can be at issue. If John Doe passes away and James and Susan are fighting over whether we're using the right will, is this the will that he gave James, or is this the more recent one he gave Susan? Which one is effective? You can kind of have the battle of which will is the right one. At that hearing where we validate the will, then the court will appoint the administrator, the personal representative or executor, and the court will issue a legal document called letters testamentary. And those letters testamentary, it has the court's letterhead on it. It's an official document that the judge signs, and it basically empowers the executor to go and execute on what the court says is supposed to happen with the estate. Sometimes, it can take a while for an estate to wrap up, but there can be things that need to happen in the pendency of an estate, and there may be some expenses that have to be paid out of the estate, before everything gets distributed to heirs. And so that administrator would use those letters testamentary to say, hey, the probate's not wrapped up, but I'm the point person. I get to pay this medical bill, or I get to pay for the funeral, those types of things. You catalog the assets, just a list of the assets. You identify who the beneficiaries are. These beneficiaries are spelled out either in accordance with your will, if you say, I want it to go to these people, or in the absence of a will, there are a set of laws called intestacy laws. And intestacy laws just say, if I die, who gets my stuff and in what order. It's kind of an order of operations for who inherits from me. So first in line is your spouse, and then your kids, and then your parents, and then your siblings, and then your aunts and uncles, and then we get really remote in terms of how far down the line we're going. So we identify the beneficiaries. Creditors get to be notified, because if they're creditors of your estate, they have a claim on the estate. Disputes are resolved, and hopefully there aren't any. And then finally, you distribute the assets, and the probate case is done. So lengthy process, but hopefully that's helpful in just kind of knowing what probate looks like. Any questions on that? Okay.
Jared,
Yes, sir.
how long does that process take?
It's going to depend on the complexity of the estate. If it is an uncontested probate, meaning nobody's fighting, we all agree this is the right will, and the court doesn't have any delays, I would say an absolute minimum is 3 months. Typically 6 months to a year is more likely. But that's a great question. So it can draw out. Yes, sir.
I was just going to say, I'm currently going through probate right now. I'm the executor of my sister's estate, and we're in step 1 right now, but my attorney, it's very simple. And he said probably anywhere, 100 days. But it's super simple. It's not complicated at all. It shouldn't have any issues. But at minimum,
State law requires, like for these posting and waiting periods and for notifying creditors, there are timelines that state law requires. You have to let so much time go by before you can even hold a hearing for the next step. And then practical reality is you're going to be subject to that probate court judge's calendar for when he has availability. And they're not going to have availability 8 to 5 Monday through Friday, right? Certainly not on the weekends. So those are some of the things that can draw it out. Yeah.
I'm just curious,
Uh-huh.
what keeps the executor in line to hold to the judge's decision?
Say again.
Who keeps the executor in line to make sure that they did what they were supposed to do?
The court. So they would have to report to the court, any decisions that they've made. There'd be a kind of a final accounting. If, let's say in our example of John passing away and James and Susan, let's say James is the executor and Susan is worried that James is going to spend all of the resources down in the pendency of the probate and then come back and say, oh, there's no money left, sis, I'm sorry. Susan can require, if she thinks something shady is going on, she can go to the court. She can seek an order to remove him as executor if she thinks he's doing wrong things. She can seek for an accounting of how everything has been spent. She can come in and say, hey, I should be the executor. We should be co-executors. So you're not without recourse if you feel like an executor is not handling things the right way.
So things could be stuck in probate for a long time.
Things
Sounds
can
like
be,
there's a lot of, this could be a mess
Yes.
after mess after.
yes. If you have 6 kids and all 6 kids have a different will and you have assets in 5 states, things can get hairy. All right, unless there are any other questions on wills, and if there are, we can spend as much time on it as needed. Let's talk a little bit about another document that works really well to help address some of what I think some of the weaknesses are of just using a will. A revocable living trust, you'll note it's revocable. It's in the name, right? We can amend it, we can change it. We can do all of those things during our lifetimes. And it's basically just rules of the road. It's what you want to have happen with your assets and with your income while you're alive and in great shape, in the event that you are incapacitated, unable to make decisions for yourself, and then what you want to have happen whenever you pass away. It's basically a private will. Earlier, we talked about a will being a Dear Judge letter. A private will completely avoids probate. It avoids the associated costs with probate as long as we've created the trust, and you'll see in a moment one of the important things is to actually fund the trust. We got to put stuff in it. The trust has to actually own assets. But if we do that, then our assets, all of our business, once we've passed away, it's not open to public records like a probate is. If you pass your assets down via the probate process, if you want to look up anybody's probate, you can do that. You can go to oscn.net. It's a Oklahoma Supreme Court net website, and you can look up probate cases. And is there a reason why someone would want to do that to you? Maybe so, maybe not. But if you want to keep it private and you don't want the ability for anyone to look up your estate and to read your documents, then you don't have to do that. You can use a trust instead of a will. It really provides you maximum customization for exactly what makes the most sense for your family. You and your spouse, you and the person that you live life with are going to know better than anyone else what is most appropriate for the people that are important to you. For your kids, what access to assets do you want them to have? For anyone else that you would name in your estate, you're going to have a better sense for that than anyone else. And so with a trust, let's say that you have, we'll walk through maybe a couple of what ifs. What if we have minor kids? What if we're creating an estate plan and we have minor children? Well, right now, I have a sense for how Brooklyn and Jack, my 12-year-old, and my 7-year-old, I have a sense for how they think about money, but I have no idea how good they're going to be with it. And if Lindsay and I were to drop dead tomorrow, when they turn 18, because that's the age of majority, that's when you become an adult in Oklahoma, do I want them to all of a sudden have financial resources that they can 100% access with no guardrails? I know what I would have done at 18 years old. I would have gone out and I would have bought a big house, and I would have bought a 1987 Toyota Supra, and I would have souped it up and put a sound system in it. And I don't want my kids to do any of those things, right? And so I know that they need some guardrails. They need someone to help provide a path for them to get access to the income that they need to go to school, to live life, maybe a down payment on a house, maybe pay for a wedding, maybe buy a reasonable car. We're not buying Lamborghinis, we're buying used Honda Civics. Those types of decisions. But that's what a trust can help you to do whenever you have minor kids. As your kids grow up, if you have adult children, you have more line of sight now at this point to maybe how they think about money. Are they good decision makers? Are they not good decision makers? And so you can customize their access to financial resources for them. For one kid, it may make sense to say, hey, whenever mom and dad pass away, you will inherit these assets, and you can take them free of trust, meaning they're yours. They go to you in your name. You are 100% the decision maker. If you have an adult child that has substance abuse issues, or has a criminal history, or has gone through multiple marriages, or is prone to bankruptcy, or just has financial trouble, sometimes money is not a blessing. Money's a magnifier. And so getting money at a time of life where maybe it's actually going to be harmful for you, we don't want to do that, right? We don't want to curse the next generation with resources that's actually going to cause harm. And so a trust can really help to provide those safeguards to say, hey, if we have a kid who's troubled, you don't get to be your own trustee. You're not the decision maker. Someone else is the decision maker for you. You can get access to resources to pay medical bills and pay your rent or mortgage, but not go on a trip around the world or do crazy things. Just a few other, and we could spend an entire class just on revocable living trusts because there's a lot to unpack there. A few other things. So it reports under your Social Security number for tax purposes. So if you create a revocable living trust, you don't have to worry about filing another tax return because all the income, everything that flows through the revocable living trust would show up on your personal income tax return. So it's not adding tax complexity to the picture for you or your spouse. Let's talk about funding the trust. So let's say I create this big, awesome, wonderful plan, and I know exactly what I want to have happen, and my spouse and I, we put a lot of thought into it, and we create this great trust. And it's in this beautiful 3-ring leather-bound binder. And we take it home, and we shed a tear at how beautiful it is. We set it on the shelf, and we never do anything else. We have failed because we did not fund the trust. You have to create it, and then you have to actually put things in it. If I built a house, which I did, Lindsay and I built a house. We moved into it last year. If we had not moved into it, would we be able to enjoy it? No. You build the house, you move in. You create the trust, you fund it. And so what do I mean when I say fund the trust? It means assets that have title, particularly your house. You would retitle your house from Jared and Lindsay Snider as individuals into the Jared and Lindsay Snider Revocable Living Trust, data, da-da-da-da. And so does that mean you've given up control? No. You still control everything because you are the decision makers. You still own the decisions. This trust is revocable, amendable. You can change it. But we're giving effect to the trust by having our assets that have a title to them, especially real estate. Cars are the one asset that it's best practice, but it's not the end of the world if you don't put your car in the trust. You can go to the DMV and take care of things without it. But other things that have titles, boats, land, investment accounts that are not retirement accounts. When I say retirement accounts, think back to a couple weeks ago when we talked about IRAs, 401ks, Roth accounts. Those retirement account type of accounts have to stay in your individual name. But an individual account, a joint account, a bank account, those types of assets should be owned by your trust. So we got to fund it. That's really important. So when I say potential asset protection for future generations, one of the questions that people ask sometimes around a trust is there asset protection? And when I say asset protection, if I hit someone with my car and I cause them harm and they sue me, if I have my assets owned in a revocable living trust that I create, is that protecting my assets? And the answer is no. It is not protecting your assets. That doesn't mean that you are without any option for protecting your assets. There are other things that you can do to protect your assets, like have the right types of property and casualty insurance. But it's not going to protect assets for me. It can potentially protect assets for my kids. And so for married couples, it's really common in Oklahoma to create a joint trust rather than each spouse having their own trust. It's really common to have a trust that you create together. And so let's say we have a joint revocable living trust for me and Lindsay, and we pass away, and the trust passes assets to our children, but it doesn't pass those assets outright. It continues to hold those assets within the trust, but allows a trustee to make distributions to them of income and potentially principal as they need it. That provides asset protection for them in structuring things that way, because if you're not the control person, if you don't actually own it and it's not in your name, it is not part of your estate. It has protection from bankruptcy, it has protection from creditors, it has protection from divorcing spouses. So imagine, you create a joint trust, and your kids grow up and they're adults, and you both pass away, and let's say your child is going through a nasty divorce. If you pass away during the divorce and your trust says, at our deaths, these assets shall be distributed free of trust to our children, the trustee's hands are tied. There's nothing they can do. Even though your kid would be receiving those assets free of trust at a time where they're going through a divorce, all of a sudden those are assets that could be reached and claimed by that divorcing spouse. We've tied the trustee's hands. And so those are things just to think about. What kind of benefit can we pass on to the kids? We can provide some asset protection for them. And so what are the roles? What do we call the people involved in a revocable living trust? The first is a trustor or grantor or trust maker. That's you. You and your spouse are the ones creating the trust. You're also the trustee. So for Lindsay and myself, when we created our trust, we were the trustors, the grantors, and we are co-trustees. We make decisions together. We don't have to have, if we go to the bank, we don't both have to sign the check, right? We can make decisions independently of each other. We can act, independently of each other as co-trustees. when the day comes that Lindsay and I both pass away, we've named a successor trustee. That would be the person who comes in behind us to be the trustee and to step into our shoes. The trustee role, they're the person that are kind of enforcing these rules of the road. They're the traffic cop, if you will, to say, here's where we get access to income. Here's what's supposed to happen with assets. They're kind of laying that out for the beneficiary. They're who the beneficiary of the trust would come to say, hey, I need to pay for my tuition. I need a car. I need a down payment on the house. That's the successor trustee role. And some trusts will have what's called a trust protector. A trust protector, a lot of times it's a lawyer, maybe a corporate trustee who can step in if you have a successor trustee who's wasting trust assets or doing things that they shouldn't do. The beneficiaries of the trust can go to the trust protector and say, hey, time out, this successor trustee is doing things wrong. And they can have that trust protector step in, and some of the point is to reduce the chance of litigation. Because obviously we're going to a lot of trouble here to avoid probate and avoid unnecessary legal bills, and a trust protector can kind of help with that. Let's see. Before I jump to the steps to create an estate plan, I'm going to go back. So on this revocable living trust concept, what questions do you guys have? Anything that kind of comes to mind or percolates around how this sort of works? Yes, sir.
Let's say Samson and Hope put together a revocable living trust. They got their 3 kids.
Yeah.
But let's say they're not done. Okay? So they have 3 more kids.
Yeah, 3 more.
3 more.
Okay.
So, do they have to modify it every time they have a new child, or how does that work?
Great question. It's going to depend on how their trust is written. If they wanted to keep it really, really simple, I would argue maybe simpler than what it should be, and they just want the trust to say, at the second to die of us, we want all of our pay our creditors, and then we want all of our assets to be divided equally among all our children at the time, free of trust. That's really simple. They could just say that, and then they could have however many kids, and the trust speaks to that. If they want to be really specific, and right now we've got 3, and we spelled out what happens with these 3, and then baby number 4 comes along, then you just do a trust amendment. You come back and you say, hey, we've had kid number 4, and we're going to give effect to them. A lot of times I see whenever people have grandchildren, they may, as you learn about kind of who your grandkids are and what the nature of those kids are, there can be. It might be appropriate when they're really little to just have a kind of a blanket provision for grandkids. But then when that 3-year-old that's so sweet and cute turns into a bratty 23-year-old who isn't going to spend assets very well, then hey, I got to have some guardrails if my granddaughter was to inherit these assets in the trust. Great question. Yeah.
So I have a joint trust
Okay.
with my spouse.
Okay.
He passes.
Mm-hmm.
What happens to the trust? Can it be amended from that point?
The answer is it depends. So I would say, it depends on a few circumstances. In blended families, I see it's a lot more common to say at the first to die, the trust becomes irrevocable, and we can't change it. And that's not always the right answer in a blended family, but sometimes that's the right answer. I've seen lots of trusts where both spouses want to allow the surviving spouse to make changes. And that can be true whether we're a blended family or not. You can, within the trust, you can. One thing that I think a lot of people worry about, and I think this is getting to be a bigger issue just as we are all living longer, is so I'll use me and Lindsay for an example. I always kill the guy off, like I said. So let's say I die, and in our trust, it gives Lindsay the ability to amend the trust document once I'm gone. And let's say she gets older and maybe not making as good of decisions, and she remarries and decides to leave all the assets to her new spouse and her new spouse's kids at the expense of our kids. Is that something that could happen? Yes, it's something that, in theory, could happen. Is Lindsay going to do that? No, right? Because I know she's not wired to do that. But those are the kinds of remote possibilities that you have to at least ask yourself. And a good estate planning attorney will ask you, hey, at the first to die, what do we want to have happen from an amendability standpoint? Or do we want to just carve out some assets and say, depending on the level of your assets, and if we have the financial flexibility to kind of carve out some assets and set them to the side, we may say, hey, we're going to take 25% of our joint assets at the first of us to die. That's going to get set aside right now. And it's not for the surviving spouse, it's for our kids. Maybe they can access it now. Maybe they can't access it until the second spouse passes away. But we're going to have this special carve out to make sure that we've accounted for that risk of, kind of a second marriage, remarriage kind of situation.
In simple words, what's the difference between the probate and the revocable living trust?
Mm-hmm.
And what is the cost to create the trust?
Yep. The cost to put a comprehensive estate plan in place is going to be similar to the cost to do a probate. So $3,000 to $5,000, kind of in that range typically. Sometimes it can be less expensive than that. Sometimes it can be more, but that's a good rule of thumb. The biggest differences between probate and trust are control. You can exercise more control whenever you do a trust compared to a will. Whether it's public or not, a trust is private. A will and a probate is a public process. And then the time. Typically, a trust, you're able to kind of step in and start making decisions and giving effect to the trust, to the terms of the trust more quickly than what you can in a will, because it's a legal process. It's not a lawsuit until it becomes contested, but it's handled in court, and so you're subject to the court's timelines. Does that make sense?
Jared,
Yeah.
so if we die,
Mhm.
our kids, would they be the trustees and beneficiaries?
Potentially.
Okay.
Let's say your kids are all financial rock stars. They're super responsible. They're at an age where it makes sense for them to be their own trustee. You can leave assets to them and give them the right, but not the requirement, to distribute assets at any time they want to. They can each be their own trustee. They can continue to hold assets in trust. If you are your own trustee, depending on state law, that might impact some of the asset protection features, because a court may say, well, if you're your own trustee, you really have control of the asset, and so creditors can reach it, so to speak. So that's a consideration for you. But yeah, you can be the beneficiary of a trust, and you can be the trustee of a trust. I'm an only child for my parents, in their trust. If they named me as the successor trustee to make decisions, and if they said, hey, we want everything to go to Jared, I would step into the role as successor trustee on my own behalf as beneficiary. Yes, sir.
If you have a life insurance policy or a 401k,
Mm-hmm.
and you have a named beneficiary on both of those,
Mm-hmm.
and you set up a trust
Mm-hmm.
to change the beneficiary to the trust name instead of like your children have a beneficiary in their life insurance or your spouse, do you need to change it?
Great question. So who do we name as beneficiary or owner on life insurance and on retirement accounts? On life insurance, I would name your trust as the beneficiary. So the trust would be the first in line. Whenever you receive life insurance proceeds, that's tax-free, so that's not a taxable event, but it would just flow through to the trust and then follow the trust rules. And I would have that the case as kind of the first in line beneficiary. There are times where I've seen times where folks create a joint revocable living trust, and they have life insurance, and a spouse still wants to be the primary beneficiary. I'm not going to fight with that. If we want to name our spouse individually rather than the trust, is it technically best practices? I think it's not. I think we're missing a step. But there are times where this is emotional, right? And there are times where, from a control standpoint, it just feels better for for the spouse that's the beneficiary to say, oh, that's going to be in my name, and then I'll put it in the trust. You have to have a degree of trust and comfort that would happen. On retirement accounts, what I typically recommend is to name, if we're going to say whenever I pass away, my retirement account would go to my spouse. I want them to be the beneficiary. I want them to get the benefit of that retirement account. If you've created a revocable living trust, your primary beneficiary would be your spouse, and then potentially the answer around next in line for what are called contingent beneficiaries is it's going to be an it depends answer. It depends on the nature of the kids that would be named as kind of within the trust document. If you and your wife were gone, it'll depend on their age, depend on their financial acumen if they're adults. If we feel really confident that we have adult kids and they're going to do a great job with money, then we can dispense with some tax complexity by naming our kids individually as contingent beneficiaries. So let's say I was 20 years further down the road, my kids were grown up. I would have my wife Lindsay as my primary beneficiary of my 401k, and if I feel really good about my kids and I don't want to introduce some tax complexity, I might name Jack and Brooklyn as 50% beneficiaries instead of naming my trust. But if I know that they would not make good decisions with money yet, then I may say, hey, it's worth the tax complexity that would be introduced by naming the trust as the beneficiary of a tax-deferred account like an IRA or 401k, because we got to put some safeguards around those assets. It's going to kind of come down to our willingness to sign up for some tax complexity. And what I mean by that, when you inherit an IRA, you have 10 years to take the money out and to distribute those dollars. If a trust inherits an IRA, if you don't fully distribute the dollars from the trust to the beneficiary, trust tax rates are really high. You get to the highest tax bracket on a trust at like $12,000 to $13,000 of taxable income. So whereas for an individual, if you have $12,000 of income, you're not going to really owe any tax. For a trust, you'd be taxed at the 37% bracket. So I know that's a lot of tax speak, but that's kind of what goes into the decision around on your IRAs, retirement accounts, who do you name? The safest thing to do is to name the trust. But if you have a little more insight into kind of the nature of your kids or whoever would be the contingent beneficiaries, you might name individuals. Does that make sense? Kind of?
Yeah, no, it does. I was more thinking about, like you said, like the contingent, because I have my spouse as the primary on both of them, and
Yeah.
then my children who are minors, 9 and 6,
Right.
as contingent 50-50 equal share on both. But
Yeah.
if I set up a trust, I would leave my spouse as the primary, but
Yeah.
if both my spouse and I pass away,
Yeah.
and my life insurance and my 401k have both my minor children as contingent,
Yeah.
how does that?
In that instance, I would probably name the trust. I would say, hey, it's going to be worth the tax complexity.
There's a lot of money that would be going.
Yeah, it's a big deal. Yeah, because if you just leave them as minors, first of all, the court would have to step in. The court's going to have to be involved anyway to name a guardian because they're minors, and we do that via a will in Oklahoma. So when you have minor kids, you have to do the probate thing just for the purpose of naming a guardian. But for the financial assets, you would probably want to name the trust as contingent beneficiary so that you have those safeguards in place for the kids so they don't get access to a pile of money at 18 years old. Yeah. That's it. Yeah. Just checking how we're doing on time. So we're about 5 minutes past 8. Are we good for like another 5 minutes? Is everybody okay on time? Okay. I know this stuff can turn into a snooze fest if you're not careful, so don't want to put anybody to sleep here. So here, just real quickly, here are your steps to create an estate plan, very high level. So decide what your goals are, organize your assets. 2 weeks ago, I gave you guys some of the documents to create a net worth statement, our assets and our liabilities. So do that organization work. Hire a legal professional to prepare the documents based on your goals. And that legal professional is also going to discuss those goals with you, help you maybe think through the things that you haven't thought of, maybe ask some questions to lead you to the right conclusions around what needs to be in those documents. And then the legal professional prepares them, and then you sign them. You have a big signing party, and it's so much fun. And then you retitle your assets. And that last point, to me, is the most important because we've wasted all this work if we don't do the last thing. So we have to actually fund the trust and retitle our assets into the name of your trust. Frequently asked questions. So I may not touch on all these, but just real quick. Does it shelter or protect assets? Remember, it does not do that for you, but it would do it potentially for your kids. So there are some asset protection features there. What are some goals for us to discuss? The next slide will tell you some goals, or at least some things to think about. This is a really common question. Should I put my kids on my house? Should I retitle my house to where my kid is on the house? No. You should not do that ever. You should not do that. Should I put my kids on my bank account? Maybe, but probably not. Because whenever you name technically, if we want to get really technical, whenever you are naming a kid on a house, on a bank account, that is a gift, right? They have access to that asset. And so that has estate tax implications that we want to account for. What is estate tax? How worried should I be about it? Right now, for each individual in this room, if the value of all your stuff that you own minus what you owe, if it's less than $13 million, you do not owe estate tax. As of January 1st, 2026, if Congress doesn't do anything different, that $13 million number is going to come down to about $6 million. That's still relatively high. How low has that number been? That number has been as low as $1 million, which for a lot of people who work throughout their career, 20, 30, 40 years, then you start having more people impacted by that when you take the value of your home, plus your retirement accounts, plus your bank account, et cetera. So you just kind of always have to be monitoring where is the estate tax exemption level. Right now, for most folks, it's not something to worry about. Will the government take my assets if I don't have a plan when I die? No, the government is not going to take your assets. There are rules that the government has laid out around what happens to your assets, but the government doesn't just take them. Should my trust own all my assets? And I would say yes, with that one caveat of those retirement accounts that we talked about, because they can't be. Like my 401k I have at my company, legally, the IRS doesn't allow me to retitle that into the name of a trust. It has to be in my name individually. What happens if I own assets in more than one state? This is a great example of why a trust is really good. Because let's say I have a vacation property in Colorado, and I just own it individually, and I never title it into the name of the trust. Well, guess what my heirs would get to do whenever I die? They would get to deal with a probate in Oklahoma, and then they would get to do an ancillary probate in Colorado. And so, as you accumulate assets, you add complexity, and that's one piece of complexity we don't want to add. What do I do with rental properties in my estate plan? So if we have rental properties, I think it's good to have those owned in an LLC because it is important to have some asset protection. If you have renters in an asset that you own, they slip and fall, something happens, they sue, you only want them to be able to reach the assets of that one LLC, not all your other assets. So kind of segregating things out to say this LLC entity. LLC just stands for Limited Liability Company. It's a business entity. Have that LLC own those individual assets, but then who owns the LLC? Your trust should own the LLC. So an attorney creates the trust or creates the LLC for you, or don't let attorneys know I told you this. You can create an LLC yourself for $100 online. It's really easy. But you create the LLC, and then whenever you create the estate plan, you tell your estate attorney, hey, I do rental properties, and I have 3 or 4 or 10 LLCs, and they're going to say, okay, we're going to do an assignment of interest. We're going to assign your LLC member interests from you individually to you as the trustee of your trust. And then how do I tell my kids and my family about my estate plan? Number one, I think in time, you should tell your family that you have an estate plan. Now, the level of disclosure that you make is going to depend on you and your kids and your relationship. It may just only be appropriate to say, hey, Mom and Dad have taken the steps necessary to make sure that everything will be transferred orderly whenever one or both of us pass. There's a plan in place. Here are the important people for you to call. You need to know who our professionals are that serve our family. Here's the kind of break glass and call in case of emergency number. Or you may reach a point where you say, hey, it's time to read my family, in more. into what our assets look like, the value of our assets, particularly as you get older and as your kids get older and as you kind of contemplate what impact will these assets have on your children. There are times where multi-generational planning is important. And so it's going to depend on your kids, your family, your circumstances, but I would say in time it is good to kind of read people in to what's going on. Lots of different goals for you to think about, but what should we be thinking about? What are goals in having a good estate plan? Providing for disabled descendants. We didn't talk about family members with disability, really, but if you have family members that have disability, and particularly if they're receiving any sort of government benefits, federal assistance, it is mission critical that you do a trust, because there are certain provisions that need to be in that trust to make sure that inheriting assets doesn't derail those important benefits that they receive. We can eliminate the probate process. We can protect our kids, our grandkids from divorcing spouses and creditors. We can provide for our kids and grandkids. Avoid immature spending habits. We can plan for disability. We can pass on our values and a level of responsibility onto family members. And then, we can minimize estate and gift taxes, but that number is really, really high. So 3 questions for you to think about. What's your most important financial goal with your estate plan? That's something that should be on your radar as you're contemplating your estate. What family dynamics could impact your estate planning? That's a huge one. So really understanding your family, understanding their tendencies really would guide you in going about, putting certain terms in place. And then what are the main threats to your goals? What could kind of derail things if things went sideways? So I know that's a lot to cover. Hopefully that's not like drinking from a fire hydrant for you guys on estates. But I would just emphasize to you that it's really important to do. Is it fun? No. Does it cost some money? Yes, it does. It's money well spent. It's kind of like paying your homeowner's insurance. You pay that premium and you hope you're never going to have to use it, right? Well, the reality is this is going to get used at some point. We don't have a choice in the matter. Your estate plan will be used. You'll either use the one that the state has created for you by default, and you'll be subject to whatever that looks like, or you'll create one for yourself and be proactive and make decisions for yourself and kind of on behalf of your family. So anyway, I appreciate you guys. I think that's all I wanted to cover with you. But any other questions?
I got probably an idiotic question, it's a dumb question, I'm sure, but these are all pieces of paper,
Mm-hmm.
right?
Mm-hmm.
Are these filed somewhere? Does a lawyer hold them? Do you put them in your freezer or your safe?
Yeah.
Just a dumb question, I'm just trying to run that.
Nope. So you will get copies of the executed documents. You usually get the originals. So you have the originals in hand. The attorney is going to keep copies. If you have a wealth advisor, financial advisor, your advisor should keep copies of those for you. If you have an individual in your family that is at a place where you can say, hey, we've named you as a successor trustee, we want you to have these documents in case something happens, they should get access to those documents. They should go in a fireproof safe or someplace that's protected from destruction. You should put copies of them in, if you have cloud-based storage through your Apple account or whatever, store them on the cloud, email them to yourself. Have some level of redundancy around them.
Do they have to have the original one to
No.
execute?
No, they can have a copy, and a copy works fine. I mean, I've had clients where they lost their estate planning documents and their attorney died, and I mean, it's real life. Like, things happen, right? And so attorney dies, and their files are God knows where, and something happens to the documents. They get coffee spilled on them, and you can't read them, or you have a house fire, or something crazy happens. That's why you have a digital version of them as a backup. Good question. Good deal, guys. Anything else? Well, I appreciate it. I'll hang out. If you have questions, you can certainly ask. I've got my card for anyone that wants to give me a call or shoot me an email. Glad to help. This is the kind of thing my colleagues and I help clients with all the time is create estate plans and make sure that these types of things fit into what we call an integrated financial plan. So nothing's missing or broken, and it all fits together. So I appreciate it. It's good to see you guys.
Thank you.
Yeah, you bet.
So, next time we'll be
Yeah, we're gonna cover lifetime generosity. So what does it look like to be, from a generosity standpoint, to live a generous life during your lifetime while you're here on earth? And what are some practical ways for us to be thinking about living a generous life with our resources? Yeah. Cool. You guys are free to go.